a music conference in New York and won't be able to join us today. But she did send some good news to share with you, and we'll get to that in just a minute. Our show today will have a lot of local interest. Attorney Jeff Lake is our guest for the entire hour, and we will be discussing how he successfully mediated a resolution in Yuba County's cannabis cultivation ordinance and his progress in persuading Nevada County to try a similar approach. Welcome to the Cannabis Crusades, Jeff.
Welcome, Patty. Thanks for having me.
Before we get started on the ordinance, I'd like to bring up some breaking news on 2 court cases that will have a major impact on our lives. First, the California Supreme Court has moved up the hearing on the City of Riverside versus the Inland Empire Patients Health and Wellness Center, that was founded by my friend and colleague, Lanny Swerdlow. At the heart of this case is whether local municipalities can ban dispensaries based on zoning ordinances, a situation we have here in Nevada County. The case is scheduled to be heard in a special session on February 5th at 10:15 at the University of San Francisco School of Law. What would be the outcome if the court rules in favor of Inland Empire, Jeff?
Well, this is actually probably the biggest case in regards to the operation of dispensaries from a civil point of view that we've seen since probably the enactment of SB 420. And the reason is because in the Inland Empire case, the appellate court in the county of Riverside ruled that a ban is a form of regulation. And therefore, under the police powers of local municipalities, that cities and counties could actually ban dispensaries under that police power. So if the case is upheld by the Supreme Court, that would probably be the end of dispensaries in California, because every local city and county could decide if they wanted to enact a ban, and it would be done. Conversely, really quickly, if it is overruled, then Prop 215 would take precedence and preempt that local police power, which would force cities and counties to allow dispensaries in their municipalities. And then the question would become, how would you regulate those dispensaries?
Isn't that what's already happened, though? The minute they made that first ruling, municipalities have acted as if that is the law.
That's right, and the reason is because there was older case law. Cruz and Alls are the 2 cases that most cities rely upon that say that their police power will allow them to do that. They have taken those cases and tried to expand their holdings to be broad enough to be a total ban. Hopefully, and I think most likely, the court will overrule Inland Empire and follow the city or the county of LA versus AMCC holding, which is that Prop 215 requires the presence of dispensaries and then kicks the ball back to the counties and cities to figure out how to properly regulate them.
Well, we'll keep our eyes on this one for sure. And then on another front, Harborside Health Centers will not be closing anytime soon. The judge ruled that their landlords did not have standing to ask the court to evict them because they were violating the Controlled Substances Act. However, the judge also ruled against the City of Oakland's request to have the federal asset forfeiture squashed because the statute of limitations had expired. Is this ruling a mixed blessing, Jeff?
Well, the first part of the ruling is very consistent with normal landlord-tenant law, and that is that there are no unlawful detainer statutes under federal law, and it is not the duty or obligation of any landlord to enforce the Controlled Substance Act. That's the duty of the U.S. Attorney's Office. So it doesn't surprise me that the court found that the unlawful detainer would not be effective. In fact, I've tried, I think, in the last year, 5 or 6 very similar cases, and every trial that I've had on behalf of the tenant, we've won for the exact same reason. So that's very consistent. That doesn't surprise me at all. As far as the civil forfeiture and the judge allowing the case to go forward, a statute of limitations defense is something that says it's too late to bring the case. A lot of judges, unless they're very clear on a statute of limitations, that there's no tolling, that it's very clear, are apprehensive to stop a case before it starts. So although that ruling was against Harborside, it doesn't mean that the case is over, and it doesn't mean that Harborside can't prevail.
So this is sometime in the future. I mean, this could take years?
Yeah, depending on the docket of the court and the will of the parties. Most litigations take upwards of a year and a half. unless it's expedited or resolved.
So hopefully some other court case will come along in the meantime that will make this moot.
That would be great. Or if there's a change in the federal or law that would allow Harborside to keep going anyway.
If only.
Yeah.
Well, I'm sure thousands of patients will be relieved to still have access to Harborside's full range of medical-grade cannabis products. It is mind-boggling to me that anyone would think it's preferable to force marijuana underground where nothing is tested for purity or potency. I'm glad some cities like Oakland and Mendocino have the gumption to just say no to the feds.
That's right, and actually San Diego is going to join that list. For those of you that don't know, in the last election there was a new mayor in San Diego. His name is Bob Filner, former congressman, and just this week he directed the San Diego City Attorney, Jan Goldsmith, to stop and dismiss all of the pending lawsuits he has against the medical marijuana dispensaries and to stop code enforcement against those dispensaries based upon an impermissible use. Bob Filner also has said that he will testify on behalf of medical cannabis patients in trials, and he has in the past and probably will continue to stop the federal government involvement in San Diego. He has already written letters to Eric Holder when he was a congressman, and he has taken a very, very strong, supportive position for medical cannabis patients in San Diego, to the point that last Tuesday he attended the San Diego ASA meeting, and if you take a look at some of the media and video of that meeting, you will be incredibly impressed with the position that Bob Filner is taking. So hopefully that will be a very positive and a quick, efficient way to try to resolve the issue of dispensaries in San Diego as well.
That is great, because none of this would have come about if it hadn't been for the hard work of all the activists in San Diego and attorneys like yourself that represented us. So kudos to everybody on that front. That is wonderful news.
Yes, very exciting.
Well, let's switch gears and get to local matters here in Nevada County. They said it couldn't be done, but you did it. After 5 months of intense negotiations, you came away with a cannabis cultivation ordinance in Yuba County that is acknowledged as the most liberal in the state. What motivated Yuba County to accept the final ordinance?
Well, I think there was a series of factors, and they're all important. First and foremost, I think all the stakeholders in this issue, which is cultivation of medical cannabis in largely rural counties, understand that if there's not safe access, because you can't go to a dispensary, you have to cultivate your own medicine for you and your patients and your collective. That was acknowledged by Yuba County's Board of Supervisors, their planning, their sheriff, their district attorney from the outset. The question was, how can we put something together that may not be perfect for anybody, but that can be livable for everybody, at least to the most part? And I think the reason they finally accepted the last ordinance is because they realized it was a fair compromise. Nobody was happy with the outcome. And
oftentimes happens.
Right, and a lot of times, that's when you've got a good settlement, when everybody leaves disappointed. But I think that the final reason was because they understood that this was an issue that was very important to their county. It was not going to go away. It was not worth it to go through a protracted litigation, and it wasn't worth it to try to enforce an ordinance that was convoluted, it was unclear, it was unfair, and ultimately, I think the county of Yuba realized that if they put together something that was understandable by the patients, the cultivators, something that was easy for law enforcement or code enforcement to enforce, that it would be much better for everybody. And ultimately, as a result of hard work and dedication by both sides, we were able to put together the ordinance.
Well, good. That's just amazing. Our ordinance is so convoluted that when people, my friends, sit around and we talk about provisions, we get into arguments because even I don't understand everything that's in there. It's crazy.
It is.
So could you outline some of the pertinent provisions in the Yuba ordinance so our listeners have an idea of what we're talking about?
Certainly. And some of them, I think, were so obvious that it was, like you said, mind-boggling that we couldn't put this together from the outset. And we'll start with some of the definitions. Because in Yuba County now, you have to have two important factors, and that is protection and anonymity. So the fencing requirements, just something very simple, was changed to say that as long as you have your garden secure and your garden is not visible from normal view, then that's all you need. And it met the practical requirements, which is safety and to prevent nuisances. That was a very simple change to make a definition. Another one was, for example, where you can have your garden. One of the big changes was, instead of having one flat, contiguous space, which is very impractical, particularly in rural areas where there's mountains and trees and things in the way, we changed it to make it practical for the cultivators and not impossible. That one was just a very simple change. And then probably the biggest one, and this is something that I don't know how it happened before my involvement in either county. Both ordinances, Yuba County and Nevada County, before I became involved, had this crazy square footage type of analysis to try to determine compliance. That is just not workable. It's not fair, and it's against the law, actually, I believe, because the way SB 420 is written is by plant count. The way the Kelly case is determined is by medical need. It's not by whether you can get 150 square feet on a parcel in a certain place. It's not, it's not something where the sheriff has to come out with a tape measure and decide whether or not the canopy is too big. Well, what if somebody takes a string and they bring the canopy all back together in a tight little ball just for the purpose of the inspection? As soon as you leave, it pops back out. It's not practical at all. It's much easier for everyone to know how many plants they can have, where they can have them, how they can protect them, and whether or not that's enough for them individually or to meet their collective needs. So the way we did it in Yuba County was based upon parcel size. The smaller parcels, the more urban parcels, of course, you shouldn't have as much of a nuisance or potential for a nuisance. Conversely, if you're out in a very rural area where it's private and there's nobody near you, why should you be limited to a space where you can't cultivate enough cannabis to meet your or your collective's needs?
I never understood that, because if they allow for collectives, they should be in the outlying districts where they aren't going to bother anybody, but this ordinance that we have doesn't allow for multiple members. I mean, you are limited to the same amount of space regardless of how many people are in your collective.
That's right, and it makes it almost impossible to cultivate for more than just your own personal use.
Yeah, well, we ought to work on that.
Right, and I hope that soon we'll have everybody be able to understand that it's okay to have collective growing. In fact, Judge Dowling in the Nevada County case acknowledged that in our first application for a preliminary injunction, because the way that the Nevada County ordinance was originally written, it gave no credence at all to collective growing. Judge Dowling disagrees with that. So now the question is, how do we regulate collective growing? To me, we need to put it somewhere safe, because remember, this is just a nuisance statute. This is not a criminal statute.
Right.
This has nothing to do with federal law. It has to do with making sure that people's gardens are safe and protected and not bothering their neighbors.
How much money do you estimate Yuba County saved by mediating rather than litigating?
Well, Yuba County took a little bit different tack than Nevada County. They hired outside counsel, a very proficient and professional firm out of Sacramento. I'm sure they were expensive, and unfortunately, litigation is always expensive. I know that the Yuba County Growers Association expended a lot of money, and the County of Yuba did as well. Nevada County's taken a different tack. They decided to leave it in-house with county counsel, and although they may not have the attorney's fees that are accumulating as fast as Yuba County did, by taking away the resources at their own county counsel's office and diverting the attention of their attorneys towards this issue as opposed to doing something else, it is certainly something that is expensive for other ways. Yuba County, I'm sure they probably spent upwards of $100,000 or more just to this point, and they probably saved hundreds of thousands of dollars to resolve the case as opposed to having it finish out the litigation and go to trial.
Yeah, well, Nevada County claims it isn't costing them anything for the reasons you mentioned, that it's in-house. And even if insurance picks up most of the tab, I'm sure there's other substantial costs to the county.
Oh, sure, of course. And they start at the beginning and go to the end. Like I said, they're allocating resources somewhere that could be allocated somewhere else. They're going to have to hire expert witnesses. They're expensive. They're going to have to put their case on. Now, remember, the county doesn't have to pay for costs, court costs, because they're a governmental agency, but they still have other costs. And then lastly, the way the county is, I think, utilizing their resources the wrong way is through enforcement, because they're trying to use the sheriff's department, administrative officers, county council to go through the enforcement of the ordinance as written, in which I think is completely backwards. If they had an easy ordinance, they could enforce it a lot better. Nobody would be spending those time and resources.
I know that if we come up with something similar to Yuba, that they will need less enforcement because people will be able to comply more easily.
That's right, and it'll be a lot easier to enforce from the code enforcement point of view. You can count plants in 30 seconds, and people will know immediately whether or not they're in compliance.
Well, I was listening to the audio archives of the Board of Supervisors meetings on April 24th and on May 8th when the ordinance was passed. And Allison Barrett Green, Sheriff Royal, Ed Schofield, and Nate Beeson all stated that the ordinance is just a starting point. Let's listen to Allison Barrett Green, and I'd like your comments.
Sure.
We go through enforcing it, we find we wish we had done this or we hadn't done that. There is a process for that. It is called amending the ordinance. We expect, like as with any program that we implement, we will be coming back periodically to tell you how it's going, and we will be suggesting changes, improvements as things move along. But we need the anecdotal evidence to look at to see what is actually going on in the field. And this ordinance will provide us with that basis to get started. So.
Have you suggested to County Council that we attempt mediation in Nevada County, and have they responded one way or the other?
Yes, in fact, I remember that meeting. I was there when Allison made those comments, and they were echoed by lots of people there. And we knew from the beginning that what they were trying to do was a starting point, and I've been told consistently for a long time that once the facts were known, and once we got through last season, once we saw what was going around us in other counties, that the county would be willing to listen, that they would look at things with a fair eye to their constituents and for the safety of the community. And I've had many discussions with County Council throughout the entire process of the Yuba County negotiation. Their position has been consistent, and that is we would like to see what happens there. We want to see how things go this season, and we are amenable to trying to improve this ordinance if it is something that we think can be done. Most recently, we have come to an agreement with County Council that they are going to go to a closed session, and they're going to talk about the status of the litigation. My hope and expectation is that the issue of mediation will be raised, and that it will be embraced, and that the county will come to the table with an open mind and negotiate in good faith.
That would be awesome. I understand there's a town hall meeting in Penn Valley that same night as the closed session hearing of the Board of Supervisors, so maybe we'll hear something by then.
I hope so.
But I did read a remark in the Union by Sheriff Royal saying that he thought the ordinance was working just fine, that everybody was complying and there was no reason to change it. Have you heard anything different?
I did hear that, but to me, information without context is really not that valuable. I think the way that the ordinance was written is still way too restrictive and way too confusing. And if the idea is that that's what the county wanted, and that it is going to be essentially a de facto ban on collective growing, then I would say they've got exactly what they wanted. The problem with that is I think it's unfair and it's illegal. The way that the ordinance was enforced last season was new. It was kind of off to a rocky start. I have to give credit to Sheriff Royal and most of his people that they were pretty compassionate when they went out to small gardens and they tried to give people information. They did bring, I thought, too many, but quite a few enforcement actions. And because of the timing of those actions and the people that were either willing to comply and abate or try to meet the other regulatory provisions of the ordinance, we got through the season. I don't see that happening again this year. If the enforcement efforts start early, if they are in earnest, and really it is nothing more than a tact to have a ban on cultivation in the county, I think we'll see a very different result this season.
I imagine they would start the compliance checks a lot earlier than they did last season too. I mean, they didn't even start till September. They could start as early as April if they wanted to this season.
That's right. And one of the reasons for that, I think, is because they didn't even have any administrating hearing officers selected until September this year. And now that they have people in place, if they're if they're still willing to do the work, they've gotten over that hurdle. It's something that was important. And last season they didn't have the time and opportunity to get those people appointed.
It was interesting too because one of the primary reasons for the urgency ordinance was based on Yuba's strict ban in their county. They said, we're going to get a massive influx of people from Yuba into Nevada County if we don't have something in place to counteract that. So now I guess we're going to have a massive influx of people from Nevada County going to Yuba.
Right, a mass desertion to Yuba County where they know that they have something to look forward to. Well, I hear that argument a lot. I hear, it's just another NIMBYism argument. Every time somebody does something, somebody else thinks it's going to impact them negatively, and in my experience doing this for a long time, that almost never occurs.
Well, let's play another soundbite. This is Sheriff Royal stating how many complaints his office received on a daily basis in 2011 and one of the reasons he used for the urgency ordinance.
So I'm trying to use this as a lead-in on how we got here today. When we reflect back last year, during the grow season, we received on a daily basis roughly 20 to 25 complaints from the community.
So how many complaints did the sheriff turn over in your discovery request for 2011?
Right. In 2011, we actually did a public records request on the county asking specifically for the complaints that Sheriff Royal made reference to at those Board of Supervisors meetings. And I'm not sure how many requests were actually received by the county. There may have been some. I don't know what form they took. I don't know when. I don't know who processed them. I don't know how. All I know that is in our initial document request through the public records request in 2011, we didn't receive any complaints.
No, zero.
None.
Oh, that's very interesting.
Right.
So how many complaints did they say they received this year, and how many were turned over to you?
Well, in 2012, we were also, informed through many various ways that there was still a steady influx of complaints by neighbors against their other neighbors. And so we then asked for a written discovery production of documents through the litigation process. And the county did respond. And there were a number of complaints that were provided to us. The problem was that the complaints that were given to us were mostly redacted. So we couldn't get the information that we needed to know to put together an accurate analysis. We couldn't tell who was complaining. We couldn't tell why they were complaining often, where. And it made it very difficult to see if it was one person complaining 1,000 times or 1,000 people complaining one time. I do know, because of what happened during the litigation and some of the complaints we saw, that there were neighborhood feuds that had arisen and that some of those people were bombarding the county with complaints. And in fact, it went so far, neighbor against neighbor, that there were neighbors in the community that were posing as the sheriff and issuing what they purported to be official complaints on behalf of the county. So the number of complaints I think is really irrelevant to the point of view that, of course, people have a right to complain if there's something wrong, but people were taking it too far. It was like one competitor complaining about another so that they could drive them out of business. In this case, it was one neighbor complaining about another to drive them out of a neighborhood, and that is exactly the opposite intent, I think, of this ordinance.
It is 12:31 and you're listening to Cannabis Crusades on KVMR FM, Nevada City.
ASA's main complaint with the ordinance is something we've touched on, is that it replaced the state-sanctioned 6 plants per qualified patient with square foot limitations for a garden. Let's listen to Cliff Newell on the next soundbite.
Question really, Cliff, thank you very much, is if there are a number of people who are bona fide medicinal marijuana people that want to get together, do they have to find a large parcel somewhere to do that? They have to go find somebody who's willing to grow it for them? Is that,
as a practicality, yes. I mean, if they're going to have,
is that any different from the way it is now?
well, the the ordinance limits the size.
Right.
So it
Not the
would
plants.
limit, well, it would, by the size, it's going to limit the number of plants.
But I mean,
And
it
if you
states the size, it doesn't state plants.
Right.
Clearly, it's going to limit.
It is going to limit the amount of plants, and depending on the number of people that are going to go together cooperatively, and there isn't a limit on that I know of, they may exceed that space requirement.
How does this ordinance allow for collectives when the square foot restrictions do not increase per qualified patient?
Well, that's a very interesting question. And let me back up a little bit about Mr. Newell's comments and try to give some clarification. Back when the Nevada County ordinance was being contemplated, there was a focus group that was put together. And there was a number of discussions between cultivation experts and one person who is very influential in this area is Chris Conrad. Many people know him. He is very credible. He's very experienced. And he wrote a book that talked about the best way to measure the amount of medicine that will be required by a patient to meet their medical needs. And in his book, he opined that the easiest way to determine the amount of medicine that's necessary for a patient is not by plant count, but by canopy square footage. And his argument was based upon the idea that you could have 1,000 plants in Dixie cups, and they could grow through all the way through bloom, and they could be harvested, and each one might produce 1 gram. And that 1,000 plants was something that was not easy to quantify. What would be easier is if you push those 1,000 teeny plants together, you would have a canopy, and if it was 1,000 grams, that would be the way to determine it. Conversely, if you have one giant plant, it could have multiple pounds of medicine, not because of the number of plants, but again, the size of the canopy. And that's how he measures how much medicine can be supplied by a garden. The problem is that has nothing to do with nuisance regulation, because if you have 1,000 plants in Dixie cups and they are going to take up 150 square feet and you're only going to get 1,000 grams of medicine, that is very impractical when it comes to enforcing a nuisance ordinance. They're really apples or oranges, and I think that point was lost by the focus group when they were trying to figure out the best way to regulate cultivation in the county. Because although Mr. Conrad is right, that is a great way to measure the amount of medicine, it is not a practical or effective way to determine where and how to regulate a garden. From the
Two different issues.
Oh, they're completely different. And the problem is that in the county's view right now, they're confused by that issue. We're not talking about the best way to have a garden to get a canopy for your medicine. We're talking about a way to protect the interests of the community and still allow a cultivator to produce their medicine. That's why I think this ordinance needs to be revised. If you have one plane and it's on a hill and you can't get your canopy to be productive and healthy and provide the good medicine that you want, Chris Conrad will tell you that canopy is not what it says it is, because if it's dead, if it is moldy, if there is no medicine on it, that canopy is worthless. If there are plants that are easy to count, then it becomes up to the cultivator to make sure that those are healthy plants. And that's what a cultivator wants. They want to have room to get around their plants, to tend to them. Particularly, for example, people that are seriously ill or injured, for example, in a wheelchair. Having a 150 square foot canopy that you can't get into to tend to your plants is a worthless garden. On the other hand,
we've had that situation this season as well. I mean, Renee Johnson was forced to cram all of her medicine into a very small area, and she has Hodgkin's disease, and her whole garden molded because of that, and she lost her entire garden. I don't know how she's going to get her medicine this coming season.
Yeah, that's right, and that's a horrible shame. And the same thing is true when it comes to collective growing, because if you have a collective that's made up of 2 people, SB 420 says you're entitled to 12 plants, no doubt about it. And if you have a collective that has 100 people, the question becomes, where can they cultivate? And if you only get 150 square feet, there is no possible way that you're going to be able to supply the members of your collective. collectives are legal. They are a very common and accepted practice in the state, and they're necessary for the same reasons. If you live in a condo downtown, you can't cultivate because you may not have the ability or the space to do it. But if you live on a 50-acre parcel and there's nobody near you for miles, well, if you're going to have a collective for the members, your members, it's perfectly fair to do your cultivation far away. So why should you be restricted on the number of plants that aren't having any negative impact upon anyone? So again, this is a very big issue. The Inland Empire case is really focusing on dispensaries, but I think we'll see a lot from the Supreme Court, when they hear this, as to their views as to supplying medicine for collectives. And if they say that you can't ban dispensaries, I think that there will probably be some language in there talking about whether or not a county can restrict cultivation to supply dispensaries, or even without a brick and mortar distribution point, which is what a dispensary is, how can that model be converted into, for example, delivery or just a very rural collective? So I think the Inland Empire case is going to come out in our favor, and it's really going to help us on this issue.
It almost seems crazy to me that we're even discussing this in light of Washington and Colorado legalizing marijuana for recreational use, and here we are still arguing about how to supply patients medicine.
Right, and unfortunately, that's not what this case is about. Because I agree with you. I think that, for example, the federal government has a very important decision they have to make. Why are they going to be spending their resources trying to investigate and prosecute medical cannabis patients when they have 2 states full of millions of people that can use cannabis for recreational use?
And they haven't cracked down on them.
No, they haven't, and I wouldn't be surprised if they don't.
Why? They got California for their punching bag. Why do they need?
Right, and and that view may be changing too. But when it comes to the distribution of medicine to patients, this case is about how do you regulate it fairly. And if you have to accept the premise that people want their medicine, they need their medicine, they're going to get their medicine. And if you try to ban that in a local geographic region, one of 2 things is going to happen. Either one, they're going to go somewhere else, which is what you don't want. You want
underground?
Well, no, I mean going somewhere else geographically. Mm-hmm. And why would the government of Nevada County want to drive people away from their county? I don't think that's what they want. I think they want to have people here, they want to be safe, they want to have good commerce, and they want to have good neighborhoods. Second point is exactly what you said, and that is, if they're going to have people here, they're going to drive them straight underground and straight into the criminal elements in society that nobody wants to see flourish.
Except for, seemingly, our local officials. I do not understand the reasoning here.
Well, I don't know if I would be surprised if our local officials want people to commit crimes. I think what the local officials want is for their constituents to know that they are tough on crime, that they believe that their community needs to be safe, that they need to have a positive economic impact of the decisions that they make as leaders. And that's true not only for the elected officials, I think, but for staff, for law enforcement, for prosecutors. I don't think that anybody wants to come across soft on crime. And I agree with them. There's no problem with me with that. What I don't know, and what I hope is true, is that the elected officials, the law enforcement, and the code compliance officials, in this case this is a sheriff, are looking at this from a point of view that is fair and practical, and not something that is their own personal agendas that they think that they need to drive through for whatever individual reasons, but that they do look at the entire breadth of the community. It's a very complicated issue. As the earlier soundbite said, a year and a half ago, 2 years ago, nobody knew what to do. They had never had to deal with this before. It was the first shot at it, and now that they've had an opportunity to see what's going to happen, that they'll look at it and say, you know what, you're right. There's nothing wrong with sitting down and talking and improving,
Judge Dowling ruled in Southgate v. Johnson case that something that is legal under California state law cannot be declared a nuisance. Does this have any bearing on our cultivation ordinance in case?
Well, yes and no.
Always.
So, I know. I'm
Always
sorry.
yes
That's the trouble. That's the trouble with lawyers. We hate to commit to anything. No. What he meant by that is that if you're allowed to do something, you can't be told that you can't do it. But just because you're allowed to do something doesn't mean that you can do it any way you want. So, for example, if you have a right to cultivate medical cannabis for your personal use, it doesn't mean that you can do absolutely anything you want, anywhere you want.
But presumably you could do what the state law says you can do.
That's right. That's absolutely right. The problem is that there is a conflict in the law on a lot of these issues, and there is a vacuum because a lot of cases that have come out in the last couple of years that tried to address these issues of how do we allow people to do something that they're entitled to under the law and not expand it to the point where it impinges upon police power or it creates a problem for your neighbors. A lot of those cases have gone up, and then they've gone up again, and they're sitting at the Supreme Court. And what happens is when you've got a conflict and people want a resolution, there's only a couple ways that you can handle it. You can either do it privately, or you can do it publicly. And the court system really is nothing more than a forum to resolve public disputes. And that's a judge's role. And even in our case, there's a dispute between the county and the medical marijuana community as to how to protect our rights under California state law and not impinge upon the police powers and the neighbors of the community. And unfortunately, when there's no case law, it puts judges in a really difficult position because they have to make a choice based upon a lack of information, a lack of law. No judge wants to be making policy. They want to be interpreting the law to the best of their ability. And when the law keeps changing, it makes it very difficult to resolve things in a public forum, which is why I am such a strong proponent of mediation, because I think that parties should and could and must try to resolve their differences in private and resort to the courts as a last resort for a lot of reasons. It's expensive, it's time consuming, it's it could take forever to have a case work through the courts. Just our case alone, if there's a motion and there's a ruling by Judge Dowling and the other side doesn't like it, the very first thing they're going to do is appeal to another court. And if they don't like the ruling there, they're going to appeal it to a higher court. And in the meantime, what happens? Nobody knows because there's no resolution. So if the parties have ideas that they think are important to them, for example, from the Americans for Safe Access perspective, this whole idea of a canopy square footage, like we said, good idea to measure, how much medicine for a person. Very, very difficult, almost impossible to enforce accurately and effectively. If this was changed from a square footage to a reasonable plant count, which is exactly what Yuba County did, it was embraced by their sheriff, it was embraced by their district attorney, it was embraced by their planning department, and ultimately it was embraced by their supervisors. That was one major fundamental change, which doesn't impact anybody negatively at all. It means we want to figure out how many plants can be in a certain place that can give people enough room to get their own medicine and get their collective medicine. Let's change this from a canopy to a plant count. Now, the number of plants was something that we negotiated for months. It went back and forth and back and forth, and there were very good reasons why the government wanted to restrict the number of plants in certain areas, and there were very good reasons why the medical marijuana community needed to have room to grow on other parcels. And I would hate to see those months of very good, very productive, and very well-reasoned negotiations be wasted in this case. I mean, why invent the wheel when we've just invented not the perfect wheel, but certainly one that is much, much better than what we have here now?
Well, is there a downside for our county to try mediation, and what would be the upside?
Well, let's start with the upside. The upside is we can resolve the matter. We can stop the litigation. We can put an ordinance in effect that is clear and effective and easy to enforce for the community, particularly because the upcoming season is right around the corner. That is
almost here.
Yeah, that's the goal. I think that's the goal for everyone, is to put some certainty and keep improving. Like Allison said, let's keep working. Let's keep this better. So from that point of view, there's a huge upside and no downside. The only downside I could think of is that there is some reason that the county does not want to resolve this case or does not want to see a change in the ordinance because it might expand the ability of patients to cultivate.
If they refuse to mediate, are there other remedies than our lawsuit?
Well, Yes, you can go into court and ask the judge to order a mandatory settlement conference. And the difference between a mediation and what I call an MSC is that in a mediation, it's purely voluntary. The parties either want to be there or they don't. Judge can order the parties to the table. The trouble is, even if a judge does that, if the parties are not there in good faith, nothing will be accomplished.
You could take the horse to the water, but you can't make them drink.
That's right. It's really going to be up to the county to decide whether or not they want to listen to the arguments that we've been talking about for months and see if we can make some positive changes. If an MSC doesn't work, then we can keep grinding away at the litigation. We can continue to file motions. We can continue to get rulings as the law evolves. We can take different tacks, and as enforcement starts to occur, more individuals can bring individual claims and individual attacks upon the ordinance, because there's a difference between what the ordinance says on its face and how it's applied to actual people. And last year, we really didn't have any reason to bring any as-applied challenges because the enforcement was so late in the season. Mm-hmm. This year, my expectation is that if there's going to be enforcement, there are going to be a lot of as-applied challenges, and I think Judge Dowling is going to find favorably on behalf of the cultivators that are not able to cultivate their medicine under the current ordinance.
There's always an initiative, too. We cannot let this drag out for years and years without resolution, so we're looking into that avenue as well.
That's right. And not only it could be a local ballot initiative, it could be a statewide ballot initiative. There's a lot of grassroots that can be done, and there's a lot of things that can be done at a statewide level, too.
I imagine that both will be done. I know that with certainty that there will be another ballot initiative in California on the legalization for recreational use as early as 2014 and for sure by 2016.
Right, and I expect that the entire marijuana community is going to change dramatically over the next years. My concern, though, is the present. I want to make sure that this county is safe and secure, and that the patients that need their cannabis can get it, and I want to make sure that they can get that resolved as quickly as possible. I am not interested in waiting until 2014 or 2016 to wait and see what somebody else does. I think we need to do it now, and we need to do it right, and I really strongly encourage that everyone involved in this issue take an open-minded and serious look to roll up their sleeves, to get together, and to try to get this problem, if not solved completely, but certainly improved as quickly as possible.
Depending on how the court cases go and they allow for dispensing units, what would happen in Nevada County? We have a ban in place. Would that be moot, or would it have to be challenged still?
Well, interesting question. Again, it depends what the politicians do. But if Inland Empire is overruled, then the ban on dispensaries will be unenforceable. Now, does that mean that anybody can put a dispensary wherever they want? No. It's going to be then incumbent upon the leaders of the community to come up with a fair and legal regulatory scheme. What it does mean, though, is no matter how that is ultimately decided, that there will be a dispensary in Nevada County, and there will be a dispensary in every county and every incorporated city throughout the state if somebody is willing to meet the regulations and follow the rules. It will not be precluded. It's preempted by Prop 215, and you will see a dispensary in Nevada County.
My big concern is if a lawsuit is adjudicated in that direction, and if no process is put in place beforehand, it's going to be like when Prop 215 first passed. There's nothing to go by, no regulations, no guidelines, free for all, and that leads to all kinds of problems.
Right, and that's the problem that we've seen in Southern California. Like I mentioned earlier in the show, there was a de facto ban of dispensaries in San Diego, and it resulted in dozens of lawsuits, and it resulted in a ton of commotion. And now, finally, we have a strong mayor who has recognized that and is trying to solve the problem. If there is no action taken by the local government to try to implement a local fair and legal regulation when it comes to dispensaries, you're going to see the same thing here and throughout the state that you see in San Diego and Los Angeles, and it's massive lawsuits taking up a ton of time and a ton of money and a ton of aggravation, which again to me is totally unnecessary if everybody can get together and be proactive at the front end instead of trying to clean up a mess and fight and litigate on the back end.
Wouldn't it make more sense to put something in place, even if they have it in their back pocket, that they can pull out should the court rule in favor of dispensaries?
I think so, and I think they should allow everybody to weigh in on that with public hearings and town hall meetings, and if they can't put something in place beforehand, they should be ready to implement something very quickly when the law changes, because believe me, if the Supreme Court says that you have to have dispensaries and you are unaware of that law and you are not prepared to deal with it, you're asking for nothing but trouble.
Perhaps this should come up in the mediation process, assuming we get there.
Well, I'm not sure if this is necessarily the best time to do that, because we don't know what the Inland Empire Court is, or case is going to be resolved. I think I'd like to take it one step at a time, and let's talk about cultivation at the moment. Let's get everybody to the table and start to figure out that part of the problem, the challenge, and then if the Supreme Court decides that to overrule an empire, I think we should definitely ask the county to sit down and talk to us about what we're going to do about dispensaries.
Can you dust off your crystal ball and predict the outcome of this?
If it were up to me, I would love to see an ordinance, a cultivation ordinance, very similar to the one in Yuba County enacted here in Nevada County. And I would like to see that once the Inland Empire case is reversed and Prop 215 is considered to be enforceable and all of these dispensary ordinances are found unenforceable, that we sit down with the county and try to put something together as quickly as possible so that the dispensaries in the county are in the right place and they're accessible to all the patients that need them.
So what do you think Nevada County can learn from Yuba County in this process?
Well, I think the most important lesson to be learned is that it's okay to resolve a dispute informally behind closed doors. If you put together the right people, the people with their fingers on the trigger, the people with the knowledge and expertise to make good decisions, if you're going to be fair and negotiate at arm's length, that you can come to a livable conclusion. Like I said, nobody's happy with it, but it is certainly a very, very good compromise and something that Yuba County has learned, and hopefully Nevada County will learn that lesson as well, and we can sit down and put something together.
Well, you're a great teacher for both sides, and I hope that you prevail.
Well, I hope for the sake of everyone here that we can come together and put something together very quickly.
Well, we could talk about this all day, but it looks like the clock has run out on us. Thanks so much for your experience and your knowledge and for sharing it with us today, Jeff.
It's my pleasure. I'm happy to be here, and I hope it's helpful for everyone involved.
Well, I want to thank our esteemed producer, Kelly Marino, for all of her contributions to this show, and to KVMR for giving us this platform.
Nobody's right if everybody's wrong. Young people speaking their minds are getting so much resistance from behind. Time we stopped. Hey, what's that sound? Everybody look what's growing